Petition Small Claim, Case Number, Plaintiffs versus Defendant in the Justice Court, Precinct 1, Place 1, Wichita County, Texas. Include the defendant's address and the complaint. The basis for the claim, which entitles the plaintiff to seek relief against the defendant, is relief. Plaintiff seeks damages in the amount of and/or return of personal property as described as follows. Be specific, which has a value of. Additionally, plaintiff seeks the following: service of citation. Service is requested on defendants by personal service at home, work, or by alternative service as allowed by the Texas Justice Court Rules of Court. Other addresses where the defendants may be served are: if you wish to give consent for the answer and any other motions or pleadings to be sent to your email address, please check the space and provide your valid email address. Plaintiff's printed name, defendant's information, if known, date of birth, last three numbers of the driver's license, last three numbers of Social Security, defendant's phone number. Signature of plaintiff or attorney, the address of a plaintiff or plaintiff's attorney, if any, city, state, zip, phone, and fax number of plaintiff's or plaintiff's attorney, if any. Small claims cases, instructions and information regarding filing suit. Please read carefully before completing the petition. Number 1, a small claims case is a lawsuit brought for the recovery of money damages, civil penalties, personal property, or other relief allowed by law. The claim can be for no more than $20,000, excluding statutory interest at court cost, but including attorney's fees, if any. Number 2, in all civil suits, the defendant has the right to be sued in the county and precinct in which he resides. You must have a physical address, not just a post office box, for the defendant in order for him to be served in person. The last three numbers of the defendant's driver's license and the last three numbers of the defendant's Social Security number needs to be furnished if available. Number 3, in order for any potential judgment you may receive to be valid, it is necessary that you sue the defendant in their legal capacity as listed below. Personally, an individual is responsible to you for damages he may have caused you as an individual. Ergo John Doe. Proprietor or partnership, a business that is not incorporated but does have on file with the county clerk an assumed name. Ergo John Doe, DBA Greenhouse Supplies. Corporation, the business which has allegedly caused you damage is incorporated, and therefore it is necessary to know the individual's names who is able to accept service on behalf of the corporation. You may obtain the name of the authorized agent for service from the Secretary of State at 1-800-252-1386. Ergo Greenhouse Incorporated, serve John Doe. It is also possible for an incorporated entity to have an assumed name. Ergo Greenhouse Incorporated, DBA Greenhouse Supplies, serve John Doe. Number 4, if as a plaintiff you are in the business of lending money and charging interest on that money, either primarily banks, credit unions, savings and loans, or secondarily credit cards, you must file a debt claim suit instead of a small claims suit. The same applies to suits brought by an assignee of a claim by a person seeking to bring an action on an assigned claim or by a collection agency. Number 5, when you file your suit, a case information sheet and a military affidavit for individual only must be filed with the petition. Once you have filed a suit, this court will give you a receipt showing your cause, case number, and the office phone number so that you may call in periodically to determine the progress of your case. It is of utmost importance that you refer to your cause number when calling or transacting business with the court. Number 6, when you have completed the petition stating the facts and circumstances of your suit, a citation along with accompanying Copy of your petition will be served to the defendant, notifying him that a suit has been filed against him in this court. The citation will order the defendant to file a written answer with the court no later than 14 calendar days following his receipt of the citation. If he fails to do so, you then become eligible for a default judgment up until the time an answer is filed. If the defendant answers the suit, a trial date will be set. The plaintiff and the defendant will be sent notice by mail of the court date. We discourage no motions for continuance. However, if it becomes necessary, any request for a continuance must be in writing and should be filed as soon as the need for continuance is known. If you have witnesses to your suit who will not or cannot come to the court voluntarily, you may ask this court to subpoena those individuals prior to trial. This request must be in writing and must include the names and addresses of all those you want to subpoena. The request should be filed as soon as possible, allowing at least a week for service of subpoena. This type of suit does not require hiring an attorney. However, you are free to do so if you wish. This court does not collect the judgment for you, nor can we force the defendant to pay the judgment. If you receive a judgment for your claim against the defendant, you may request an abstract of judgment and or a writ of execution to help you in your collection of this judgment. An abstract puts a lien on any real property the defendant may own in the county where the abstract is filed. Abstracts may be filed in more than one county. It is suggested that you wait until the appeal period has ended, which is 21 days after the judgment is signed. A writ of execution may be obtained 30 days after the judgment is signed. This document authorizes the constable or sheriff to seize any assets belonging to the defendant that are subject to this writ. Those assets are then sold and the proceeds are applied to the judgment. If your judgment is for recovery of a particular item, the writ may specify that the item be seized and returned to you. As a plaintiff, you have the burden of proof to show by the weight of the evidence that the defendant is the proximate cause of your damages in the capacity which the defendant was sued. All damages and evidence necessary to meet your burden should be available at the time of filing. It is imperative that you provide us with your day, time, phone number, and notify us immediately of any changes in your number, or address. If you have any other procedural questions, please ask our civil department and we will try to answer them. Any legal questions may not be answered by this court. Self-help legal information packet. Filing a small claims case. Self-help legal information packets are provided for the benefit of justice courts and individuals seeking access to justice through the court system. They do not constitute legal advice, and the court is not responsible for the accuracy of the information contained in the packet. Texas Justice Court Training Center 2019. TJCTC is a division of the Texas State University and an educational endeavor of the Justices of the Peace and Constables Association, funded through a grant from the Court of Criminal Appeals. What is a small claims case? When a person or company feels like someone else owes them money or has personal property that belongs to them, they can come to justice court and file a lawsuit called a small claims case. The person or company who files a case is called the plaintiff, and the person or company they file the case against is called the defendant. What can I file a small claims case for? You can file a small claims case if you have a claim that is within the justice court's jurisdiction, meaning the type of cases that court can hear. The four most common reasons that plaintiffs file small claims cases are: 1. The defendant made a promise and then didn't honor the promise, which caused the plaintiff to lose money, breach of contract. 2. The defendant owes money to the plaintiff and will not pay. 3. The defendant did something that caused damage to the plaintiff's property or caused injury to the plaintiff. Or 4. The defendant is in possession of personal property that belongs to the plaintiff. What can I not file a small claims case for? You cannot file a small claims case if 1. The amount of money you are trying to recover is more than $10,000. 2. You are trying to recover a piece of personal property that is worth more than $10,000. A hearing may be necessary after you file a case for the judge to determine if the property is worth more than $10,000. Number 3. You are trying to recover or obtain title to real property, land, or 4. You are suing for defamation, libel, or slander, things the defendant has said or published about you that you may believe to be false and harmful. You also cannot get an order from a justice court to make a party do something or stop doing something. For example, you could not get an order for the justice court to make the defendant perform services that you paid for but didn't receive, stop posting things about you on Facebook, or cut down a tree that is hanging over your property. What do I file a small claims case against? You must file the case against the person or company that is responsible for your damages, lost money, or that has your personal property. If you are suing a business that is not a corporation, you should check with the county clerk to see who the owners or partners of the business are. If the business is a corporation, you will need the name of the registered agent, president, or vice president of the corporation. To determine the legal nature of a business, you may 1. Go to the assumed names records maintained by the county clerk. 2. Contact the Corporation Division of the Office of the Secretary of State at 512-463-5555 or go to their webpage at sos.state.tx.us to find information and assistance. Or 3. Contact the Office of the State Comptroller at 1-800-252-1386. When can I file a small claims case? You can only file your claim for a certain amount of time after the incident occurs. This is called the statute of limitations. In a breach of contract case, the time period is 4 years, unless the contract gives a different time period. In most other cases, the time period is 2 years. If you file a case where the statute of limitation has run out, you will lose the case. If you are unsure if the statute of limitation has run out in your case, you may wish to consult an attorney. Where do I file a small claims case? Small claims cases are filed in a justice court and the case will be heard in front of the justice of the peace. You can technically file the small claims case in any justice court in Texas. However, if you file in the wrong venue location, the defendant can have the case moved to the right location. If that happens, you may have to pay the filing fees again. So it is a good idea to file the case in the right venue to start with. So, what is the right venue? Generally, a case can be filed 1. In the precinct and county where the defendant lives. 2. In the precinct and county where the contract was going to be performed, if it is a contract case. Number 3. If the precinct and county where the damage to the property or injury to the plaintiff occurred. Or number 4. If the precinct and county where the personal property the plaintiff is suing for. How do I file a small claims case? The first step in filing a case, unless you are suing a doctor for medical malpractice, in which case you should consult with an attorney, is to file a petition, which is a form that says who you are suing, why you are suing them, how much you are suing them for, and provides contact information. You will also have to file a civil case information sheet indicating what type of case you are filing. The court will have petition and civil case information sheet forms for you to use. When you file the petition, you will have to pay a filing fee. Also, the petition and citation, the notice from the court to the defendant that they have been sued, must be served on, delivered to the defendant. This can be done in person or by certified mail or registered mail. And if it is done by mail, there must be a return receipt requested with restricted delivery. Important, you are not allowed to serve the paperwork yourself. You can either hire a private process server to serve the paperwork or pay for the constable, sheriff, or clerk of the court to serve the paperwork. The fee for this service varies from county to county. See the court for details. If you win your case, you will be awarded the fees that you had to pay in addition to any other money you are entitled to recover. What if I can't afford to file a case? Courts must not deny your access to justice simply because you cannot afford filing fees or service fees. If you are unable to pay those fees, fill out a statement of inability to afford payment of court costs form. The court must provide this form to you. You must swear to the information that you provide on this form and can face legal consequences if you do not fill out to the best of your ability. Fill out the form completely and truthfully. Do I need a lawyer to file a case? While you are allowed to have a lawyer in a small claims case, the rules and procedures are designed to be simple and straightforward, allowing people to seek justice without needing to hire a lawyer. If you do not have a lawyer, the judge may allow you to be assisted in a court by a family member or other person who is not being paid to assist you. This person can help you understand the proceedings and advise you, though that person cannot speak for you in court. The court is required to make the rules of civil procedure available to you at no cost. Rules 500 to 507 are the rules that specifically apply to small claims cases. The court is not allowed to give you advice on whether you will win a case or not, whether you should file a case, who you should file a case against, or what steps you should take to win your case or collect your judgment. Questions the court can answer for you are questions like, what do I need to do to have a jury trial? Or how many days do I have to file an appeal? Questions the court cannot answer for you are questions like, can I sue someone for this? Or who should I sue? Or is it a good idea to get a jury for this case? Or am I going to win? If after reviewing these materials and the rules for small claims cases, you still are not sure what to do, it may be best to consult an attorney. What happens after I file a small claims case? Important. Make sure to keep your address updated with the court and the other party so that you will receive any paperwork or notices sent to you. The court will generate the citation, which tells the defendant that they are being sued. The citation then must be served on the defendant. You can either pay the service fee for the constable or sheriff to serve the citation, or submit a statement of inability showing you cannot afford the fee, or hire a private process server or to serve it on the defendant. Once the defendant is served with the citation, then they have 14 days to file an answer, which is their response to your lawsuit. They are required to send you a copy of their answer. If the defendant does not answer, the court will set your case either for trial or for a pretrial hearing. At a pretrial hearing, you can discuss any issues such as the need for an interpreter or for the court to subpoena a witness. Order them to come to trial to testify. What if the defendant doesn't answer? If the defendant doesn't file an answer within a 14-day period, you can ask the court for a default judgment hearing, where you can prove to the court that you are entitled to money or personal property and be awarded a judgment. To get a default judgment, you will also need to provide the last known address of the defendant to the court in writing, as well as an affidavit, document signed in front of the clerk or a notary, that you swear to be true, stating either 1, the defendant is on active duty in the U.S. military, 2, the defendant is not on active duty in the U.S. military, or 3, that you do not know if the defendant is on active duty in the U.S. military. This affidavit must also state in writing how you know whether the defendant is on active duty in the U.S. military or why you are unable to determine the defendant's military status. You can verify military service at scra.dmdc.osd.mil. What is discovery? Discovery is the exchange of information between people or companies involved in a lawsuit before the case goes to trial. For information about discovery after a judgment, please see the section on What if I win my small claims case? Discovery must be approved by the judge before the other party has to provide any information or answer any questions. If you have discovery questions that you want the defendant to answer, submit them to the court with a request for discovery. Requesting the court to do something is called a motion. So you would be making a motion for discovery. The judge will only approve reasonable and necessary discovery. So if you have discovery requests, make sure they actually relate to the case. For example, asking for copies of emails that the defendant sent to a subcontractor about the deck work they did for you is likely reasonable, and asking for a copy of all emails from the defendant over the last 3 years is likely not. If you receive a discovery request that has been approved by the judge, you must respond with the requested information, or you can file an objection with the court. If you object, the court will hold a hearing to decide if you have to provide the information. Do not just ignore a discovery request. You could face penalties from the judge, possibly including dismissal of your case. How do I send paperwork to the defendant? Any paperwork such as motions, requests for a hearing, appeals, etc. must be sent to the defendant as well as to the court. You can send those papers to the defendant by delivering it to them in person, mailing it to them using certified or registered mail, using a delivery service such as FedEx or UPS, faxing it to them, or sending it by email if the defendant provided their email address for document delivery and agreed to email service in writing. On the copy you give to the court, you must write down how and when the paperwork was delivered to the defendant. What if we reach an agreement? If the case goes to trial, usually there will be a winner and a loser, resulting in someone being happy and someone being unhappy. To reduce that risk, parties will often come to a settlement or an agreement on how to resolve the case. If you come to a settlement agreement, the court can enter a judgment reflecting how much money is awarded. However, the court cannot put specific orders in the judgment, such as payment plans or deadlines. If you wish to have those in your settlement agreement, you would need to create a written contract signed by both parties. If the defendant does not honor that written agreement, you could file a new lawsuit for breach of contract. Can I have a jury trial? Yes. Either side in a small claims case may request a jury trial. You must make a request in writing to the court at least 14 days before the date set for trial and pay for a jury fee of $22. If no one requests a jury, the trial will be heard by only the judge, which is called a bench trial. What if I need more time for a trial? The court will send you a trial notice at least 45 days before the trial date. If you need more time or you have a conflict with that date, you can file a motion request for postponement, or also call a continuance. You should explain in writing why you need the postponement. Do not decide not to show up on your trial date. That will probably result in the case being dismissed. What happens at the trial? Be sure to bring all of your witnesses and documents with you on your trial date. If the trial is a jury trial, the first step will be jury selection, which is formally called voir dire. Next, you will be able to give an opening statement, if you wish, where you explain to the judge and jury what the case is about. After that, you will call any witnesses you have and ask them questions so that they can testify or tell their story to the judge or jury. The defendant will also be able to ask your witnesses questions. You can also testify yourself and show any evidence that you may have, such as documents, contracts, canceled checks, receipts, etc. Next, the defendant can present any evidence and call any witnesses that they may have. You get to ask questions on any witnesses they call, which is called cross-examination. You may ask the witnesses questions that relate to the facts of the case, but must remain calm, polite, and respectful of the court process, even if you disagree with what the witness says. Finally, each side can make a final statement called a closing argument. where you explain what you think you should do. What you think you should win. After that, the decision will be made by the jury if there is one, or by the judge if there is no jury. The decision will be announced in open court, and the written judgment will be made available. What happens if I lose my small claims case? If the judgment is in favor of the defendant, you can file a motion for a new trial within 14 days of the judgment. That means that you want a do-over. In the same justice court, you would need to show that justice wasn't done in the original case. If you file a motion for a new trial, you must send it to the defendant within 1 day of filing it with the court. Another option is to file an appeal, which is a request for the county court to hear your case. You can file an appeal within 21 days of the judgment, or if you filed a motion for a new trial that was denied, you can appeal within 21 days of that denial. If you properly file an appeal, the county court will hear the case over from scratch, de novo, and the judgment of the justice court will go away. There will be a new judgment from the county court based on the evidence presented there. To appeal, you will have to file either an appeal bond, promise from another person called a surety to pay the bond amount to the defendant if you don't pursue the appeal, in the amount of $500, a cash deposit of $500, which may be awarded to the defendant if you don't pursue the appeal, or a statement of inability to afford payment of court cost if you cannot afford an appeal bond or cash deposit. If you appeal with an appeal bond or a cash deposit, you must send notice of the appeal to the defendant within 7 days. Once your appeal is filed with the county court, you will be required to pay the filing fee for the county court, or file a statement of inability to afford payment of court costs. What happens if I win my small claims case? If the judgment is in your favor, you will almost surely not walk out of the court with a check in the full amount of the judgment. The defendant might file a motion for a new trial or an appeal. If they don't, it is your responsibility, not the court's, to pursue enforcement of the civil judgment. Below is a brief description of some of the tools that you can use to enforce the judgment. Warning, not all of these tools may be useful in any given situation. If you are unsure which of these to use, you may wish to consult with an attorney. Post-judgment discovery. You can send questions to the defendant that they must answer, describing what assets they may have that could be used to satisfy a judgment. The defendant gets at least 30 days to respond to these discovery requests. It is not required to get the judgment's approval for post-judgment discovery. Abstract of judgment. If the defendant owns real property, land, you can get an abstract of judgment from the court that issued the judgment and file it with the county clerk in the county or counties where the defendant owns the property. This puts a lien on the property in your name, which means if they sell the property, they could receive some of the proceeds to satisfy the judgment. Writ of execution. This is an order for the constable to go out and seize the defendant's personal property and sell it to satisfy the judgment. Important, many items of personal property are exempt, meaning it is not legal for the constable to seize them and sell them. To get a writ of execution, you file an application with the court that issued the judgment at least 30 days after the judgment. Writ of garnishment. This is used when another person or company has money or property that belongs to the defendant, and they are ordered to give it to you to satisfy the judgment. Almost always, this is used to take money from a bank account held by the defendant. To get a writ of garnishment, you file an application including an affidavit, sworn statement explaining why you are entitled to the garnishment with the court that issued the judgment. Important, if the person or company has no money or property belonging to the defendant, you may be responsible for paying attorney's fees related to their response. Be sure that the writ of garnishment is the best option before getting one. Resources. Texas Lawyer Referral Service, 1-800-252-9690. To check military status, go scra.dmdc.osd.mil. Texas Justice Court Training Center, information for self-represented litigants, tjctc.org. Office of Court Administration Self-Represented Litigant Site. txcourts.gov Program Services Self-Help Self-Represented Litigants. State Bar of Texas information, including legal information and low or no-cost legal assistance. texasbar.com, and then click on For the Public. Forms and information, including other types of cases. texaslawhelp.org. That ends this section for self-help. Justice of the Peace Precinct 1, Place 1, Information for Pro Se Litigants. Number 1, a pro se litigant, plaintiff, or defendant is one who does not retain an attorney and appears for himself in court. Number 2, small claims procedures are governed by the Texas Government Code. However, laws concerning justice court cases can be found in the Texas Rules of Court, including but not limited to the Rules of Civil Procedure and the Rules of Evidence. Evictions and some other civil matters are also governed by the Texas Property Code. Like an attorney, you are expected to know and follow all the rules that apply. Number 3, you are prohibited from having any contact with the judge hearing your case unless all parties and/or their attorneys are present. This prohibited communication, known as ex parte, includes phone calls, letters, messages, faxes, and emails, and direct or indirect conversations. Formal pleadings, motions, and requests for relief filed with the clerk of the court are not considered prohibited communications. Number 4, for every pleading you file with the court, you must send a copy of the opposing party's attorney. Send a copy to the opposing party's attorney or the opposing party if they do not have an attorney. Number 5, the judge, court clerk, or attorney for the opposing party cannot give you legal advice. Number 6, violations of any of the above may result in severe sanctions being granted against you. Number 7, if you do not have an attorney, the following associations may assist you in obtaining an attorney or legal advice. Legal Aid of Northwest Texas, Wichita County Bar Association. Okay, this is subpoena request form. Cause number, plaintiff versus defendant in the Justice Court, Precinct 1, Place 1, Wichita County, Texas. Subpoena request form. Date of hearing at certain time in AM, PM. Name of witness, address and phone number, and the AMT amount. Subpoena requested by plaintiff or respondent, attorney or agent. That's the end of the subpoena request form. This is the defendant's answer. Cause number, plaintiff versus defendant in the Justice Court Precinct number, County, Texas. Defendant's answer, small claims or debit claim case. This answer is made by the defendant, who generally denies each and every allegation made by the plaintiff and demands that all allegations be proven. Or further answers as follows. Describe other defenses, if any. I hereby request a jury trial. This fee is $22 and must be paid at least 14 days before trial. I hereby consent or do not consent to email service of all motions, pleadings, or other documents filed in this case to be sent to my email address as follows. Defendant requests that the court enter judgment for defendant, award defendant's costs and for such other and further relief to which defendant may prove to be justly entitled. Signature of defendant, printed name, address, telephone, fax. This is respectfully submitted by the signature of the attorney, if any, printed name, address, telephone, fax, state bar number. That's the end of the defendant's answer form.